Judge Tara Hill presided over each one of these cases and has stated during multiple proceedings that she will go through all of the appellant's exhibits, transcripts, and take judicial notice of all proceedings. So the contempt of court filed by Sadia's mother, Judge Hill says on page 7 of July 12th, 2023 hearing, she says, so I will take judicial notice of the December 11th, 2020 item, that is the other order, although it does not negate the 2019 order with regard to the 3 p.m. exchange or the 223. Day 1 of custody trial. He says, I'm going to take judicial notice of all the filing against mom or dad with regard to domestic violence and PFAs. Those entire dockets, I'm going to take judicial notice of them because I'm able to access those. So that would be any of the previous filings where mother or father was a party in any of those actions. Page 6 of October 3rd. There's a lengthy history of filing since 2015, so I will take judicial notice of all of those, and I do have the transcripts of all of those, which were requested at this time by both parties. Again, on October. Okay, so what I could do is I can take judicial notice of that. That was the proceeding. Is this the same PFA? Now this is on March 12th. She says, so what I could do actually is I can take judicial notice of that. Again on March 12th, I would take judicial notice of all the pleadings between the parties and anything that is in a predominantary system with regard to each party. Again on March 12th. Okay, so Judge Hughes did look at the prior video. Okay, and I do have that old transcript. She says, I'll spend my time reviewing the prior transcript. Again on March 12th. Okay, so we have litigated this before where you did testify about this before. So I'll just take notice of the prior litigation that we've had and transcripts that we've had with regard to the conflict between you and maternal grandmother. Again on March 12th. Okay, so you did already testify about all of this. So I'm going to refer to the prior transcript with that. Again on March 12th. Okay, so we do have all of this. I mean, I do have, your brief was very comprehensive and you did testify about this prior. Do you have anything more that you wanted to put forward on the 16 factors that's like present in the last year or 2 years? So she just confirmed right here that my brief was very comprehensive. Like I said, I submitted all of this evidence to her 3 separate times. The comprehensive brief was the first time. So again on March 12th, so these documents that may be in these court documents may be in the prior. I do believe that we have them in the prior litigation. I can label them again. So this is me submitting, I believe this time I was submitting the criminal complaints where they tried to frame me. It's not the first time. I submitted them during another hearing as well. So again, on March 12th, I'm going to go through all of your evidence, all of the exhibits. I'm going to admit all of the exhibits, whereupon all previously mentioned exhibits respectfully were moved and admitted into evidence. And they're all marked as I marked them, and I have to sort through them. And then I have the transcript from day 1 that I'm going to go through. This is a contempt of court that I filed on October 16th. She says, I'm trying to leave the record open so that you can put forward as much as you want to put forward. I'm also going through the transcript again. I have notes on each of your exhibits of what the objections from opposing counsel is. I think you have argued it thoroughly. There is a large packet that I'm going to read through again. This was the second time I submitted all of my evidence to her. The emergency petition. So on April 15th of 2024, she says, so the court will take judicial notice of, we've taken judicial notice of the entire docket in the custody trial that is currently going on but is delayed because of these findings that we're waiting for. But I will take judicial notice of all the subsequent orders which have March 14th, April 12th, April 5th. So I will take judicial notice of all of those and also of Dad's filings. In the family trial court's opinion pursuant to PA RAP 1925, the court addressed the appeal I filed on May 3rd, 2024. The court mischaracterized my claim, stating that I alleged the trial court disregarded evidence of PFA violations. The court mischaracterized my claim, stating that I alleged the trial court disregarded evidence of PFA violations by the opposing party. However, this representation is inaccurate. My 148-page contempt petition filed on August 30th, 2023, along with the accompanying exhibits, demonstrated that I am the victim of psychological abuse perpetuated by the appellee and now by extension the courts. This abuse by the courts is also adversely affecting the child in ways that are unimaginable. The record reflects the court and the appellee attempting to destroy a good man who is not only a great father but also a healer in the community. When properly examined, the record shows that I have been subjected to malicious abuse. While the court acknowledged the existence of my 148-page petition for contempt and hopefully the additional 200 pages of evidence submitted, it appears the court failed to properly consider or accurately interpret the factual content. This oversight suggests that the family trial court abused its discretion by improperly taking judicial notice of disputed, adjudicated facts and potentially relying on inadmissible hearsay evidence in contravention of the rules of governing judicial notice and the hearsay rule. Keynote 3. It is noteworthy that in Luzerne County, particularly in economically disadvantaged communities, there is a prevalent practice of obtaining protection from abuse orders as a means of abuse or winning a custody battle. Statistical data indicates that Luzerne County has consistently maintained a high rate of protection from abuse orders granted relative to other Pennsylvania counties. In 2022, this is the year that Judge Tara Toohill became judge and presided over PFAs during this year. In 2022, Luzerne County reported over 1,900 PFA cases, ranking the second highest in PFA cases per capita among Pennsylvania's 67 counties. This is a continued trend observed in previous years, such as 2014, when Luzerne County ranked third in the PFA orders granted statewide. The persistently high numbers of PFA filings in Luzerne County warrants further investigation to understand the underlying factors contributing to this trend and to ensure that the PFA system is being utilized appropriately and effectively to protect individuals from genuine threats of abuse. Improper judicial notice. The trial court's action violate Pennsylvania Rule of Evidence 201, which governs judicial notice of adjudicated facts. According to PARE 201, a court may only take judicial notice of a fact that is not subject to reasonable dispute because it is either generally known within the court's territorial jurisdiction or can be accurately and readily determined from the sources whose accuracy cannot reasonably be questioned. The contents of my 148-page petition for contempt filed on August 30th, along with other evidence submitted in multiple proceedings, contain undisputed facts. The assertions made by the court do not meet the criteria established by these facts. Reliance on inadmissible evidence, abuse of discretion,